A very good morning to all the distinguished guests, respected dignitaries, esteemed speakers, and our wonderful participants. I'm Galtarian Aparajita Bhatt. I'm a faculty of law at National Law University, Delhi, and your MC for the inaugural session this morning. It's my absolute honor and privilege to welcome you all to the Galter Mega Summit on Advanced Technologies, Law, Ethics 2026. It's a confluence of innovation, leadership, and transformative ideas. We have gathered here this beautiful morning and a historic morning in Hyderabad, not just to discuss the future, but to shape it. This summit will stand as a testament to collaboration, vision, and the relentless pursuit of excellence. As we embark on this journey together, let us remember that every great transformation begins with a single conversation. And today, we are about to have many such wise, meaningful, and influential conversations. The session, for your information, is live today on YouTube. And just to explain the flow of the session today, we are beginning with the inaugural, followed by Professor S.R. Bhansali Award Ceremony. After that, we'll be having a short tea break and plenary session in this very hall itself. So now, to embark and to mark this auspicious beginning of the summit, we will now proceed with the ceremonial lighting of the lamp, symbolizing knowledge, wisdom, and enlightenment. I invite all our esteemed dignitaries for the lamp lighting ceremony. I request Galtarian Dr. Shobha Bhandari to recite Ma Saraswati Mantra. Ma'am, can you please come up on the stage? May this light guide us towards insightful discussions and meaningful outcomes.
या कुंदेन्दु तुषारहार धवला या शुभ्र वस्त्रावृता या वीणा वरदण्ड मंडित करा या श्वेत पद्मासना या ब्रह्माच्युत शंकर प्रभृतिभिः देवै सदा वन्दिता सा मां पातु सरस्वती भगवती निशेष जाढ्यापहा। ओम शांति।
Thank you, ma'am. We also have Saraswati Vandana after this, which is being beautifully performed by Galtarian Divya Pancholia. She stays in Canada and she has sent a recording from Canada. So can we please share the recording? It's a performance on Saraswati Vandana by Divya Pancholia.
Ah शिशु है अज्ञानी माता, किन चरणों का प्यार दे। वीणा पाणी तार दे, तार दे, तार दे। माँ सरस्वती शारदे, माँ सरस्वती शारदे।
Thank you very much. And now that we have sought blessings from Goddess Saraswati, it's our privilege and honor to welcome all our distinguished guests today at this Mega Global Summit. So to formally welcome everyone and to set the stage for the summit today, I invite Professor Dr. M.K. Bhandari to felicitate our distinguished guests. So we are honored to present shawl, bouquet and memento to our Chief Guest, Honorable Justice Sandeep Mehta ji. And it's a real honor, sir, to have you here with us this morning. May I request Professor Yugal Kishore ji to felicitate our guest of honor, Honorable Justice M.R. Shah ji, by presenting shawl, bouquet and memento. Thank you very much, sir. May I request Dr. Josina to kindly felicitate our special guest for the day, Honorable Justice Suraj Govindraj ji. Thank you, Dr. Josina. And now may I request Professor Sanjay Sindhu to felicitate Mr. Tony Moron. Professor Sanjay. I also request Advocate Professor Dr. Ramlal Suthidar from Nepal. Are you here, sir? Yes. So he has brought with him special Rudraksh Mala all the way from Nepal to felicitate our guests. Kindly come forward on the stage for felicitating our guests with Rudraksh Mala. Be seated. I now request Professor Dr. M.K. Bhandari to deliver the welcome address and introduce all of us to the summit. If I were to give an introduction of Dr. Bhandari, I would not be able to do enough justice because that would take away the entire 3-hour duration for this inaugural. So just a line for him. Sir, ek line I take the liberty. And all of you would agree with me. मैं अकेला ही चला था जानिबे मंजिल मगर लोग साथ आते गए और कारवा बनता गया. Professor Bhandari.
Thank you, Dr. Aparajita. Honorable Justice Sandeep Mehta ji, Judge, Supreme Court of India. Honorable Justice M.R. Shah, former Judge, Supreme Court of India. Honorable Justice Suraj Govindraj, Judge, Karnataka High Court. Our dear friend Tony Moroni, who has come all the way from Ireland to deliver the keynote address. Our award winners of the Professor S.R. Bansali Award, Professor C. Rajkumar, Vice Chancellor, Jindal Global University, Professor Vajpayee, G.S. Vajpayee ji, Vice Chancellor, National Law University, Delhi, Honorable Justice from Jindal Global University as a visiting professor, my distinguished guests who have come all the way from different countries, Dr. Ashok Jain, Sindhu Bhaskar, Georg Molt, Angelica, Joshina, dear Vice Chancellor, friends, all distinguished Galterians, delegates, my elder brother, respected Dr. S.R. Bandari sir, Nishtha Jaswal madam, the member of the jury, Professor, and the former winner, first winner of the award, Jaswal, P.S. Jaswal sir, my dear friend, Anil Bansali ji, the managing trustee of the Professor S.R. Bansali Trust, all other distinguished delegates. This is not just a formal expression of welcome, it comes from the core of my heart. I am really deeply indebted and thankful to our distinguished guests on the dais, all our friends who have come all the way from different places in India and abroad, and all our Galterian friends, members of the organizing team, and dear friends, and also the staff of the Hotel Plaza Premium who has been cooperating with us, and nonetheless my better half, Dr. Shobha Bandari, who is a pillar of strength for me in all these organizational things. Sir, I welcome you all to this mega global summit, ATLEG 2026, Advanced Technologies, Law, Ethics and Governance. Much has been said about the developments in the space of technology, especially the blockchain, artificial intelligence, which is being talked too much nowadays, and there are many confusions about the role of artificial intelligence in our life and in our businesses, in our governance, fintech, financial technology, metaverse, a whole realm of virtual world. We could do it on metaverse and we could join as avatars. This is a virtual world. Then we have now latest development, quantum computing. The quantum computing process can be performed in a fraction of seconds, which a normal computer would take 100 years to perform. See the speed of the computing, qubit, it is known as qubit. All these developments are taking place simultaneously and we cannot stop them. Nobody can stop them. Then what is the course? What is the option? In plain and simple words, because we have a lot of experts and we have a lot of deliberations, we have to understand, may not be deeply from technological perspective, but at least as a common person, as a judicial member, as a legal fraternity, as policy makers, how these technologies are going to impact our entire system of governance, what are the rail guards or ring fencing we can create for better application of these technologies, and if there are a lot of abuses of technologies like cyber frauds. Each day one of us become victim of cyber crime, cyber frauds, because entire data of our life is with the Google, is in the dark net, is with so many platforms where we share our data for e-commerce or other purposes. So the hackers, they hack that data, they, with the help of AI, they create your digital twins, fakes, and we become victim. Even the IIT professors have become victim, not what to talk of an ordinary man. So all these issues arising out of advanced technologies need proper understanding, proper regulation, proper governance, So far as India is concerned, although we are taking lead in digital transformation, but still we have to create a proper legal and regulatory framework. Honorable judges are here. They must be also facing the cases regarding the breach of privacy. If our very own data protection law, DPDP Act, is mainly outcome of the great judgment of the Supreme Court, Puttaswamy, Justice Puttaswamy versus Union of India. So in this 3-day summit, we are going to address all these issues. Yesterday, in fact, we had 4 technical sessions, but because of the availability of Honorable Sir, we kept the inaugural today. So we are already on the job. We are already on the path of deliberations and discussions. We have published a souvenir, which is with you all, and it will be released by Honorable Sir now. So all these issues need serious deliberations. They are not like street talks. We have to seriously discuss, come together, lawyers, technology experts, judiciary members, legal profession members, from economic perspective, from management perspective, we have to sit together and evolve a strong policy framework, ethical framework, and finally the legal framework. With these words, I once again welcome you, sir, all, and my dear friends and delegates. Thank you. Namaskar. Jai Hind.
Thank you so much, sir, for setting the tone for next 2 days for the summit, and also for sharing the vision of the summit. Thank you so much. And now I request Honorable Justice M.R. Shahji to deliver the presidential address. Justice Shah has been the former judge of Supreme Court of India as well as former Chief Justice of Patna High Court. Sir, it's an honor to have you. Thank you.
Namaskar. Very good morning to all of you. I hope you must be all enjoying the good weather of Hyderabad and hospitality of my dear Bhandari ji and his wife too. My dear friend from the Supreme Court and my younger brother, Justice Sandeep Mehta, Judge, Supreme Court of India, Justice Raj, Govind Raj, Judge, Karnataka High Court, Mr. Tony from Ireland, Mr. Bhandari, all participants here, dignitaries of the dais, all who have come from various parts of the country and the abroad also. Ladies and gentlemen, in fact, I feel privileged and proud and privileged to be here amongst you and facing all of you. Why I am saying facing all of you? Because I am not that much techno. In fact, I should join the glitter for the purpose of training, which is their aim to give training and have discussions and all these things. Sir, I am ready to be your student. Please. And I am also happy and as such congratulate the Mr. Bhandari for this 3 days wonderful training summit, having sharing the views and give the training and to know what is going on at present in the world. As such, the theme of the summit, advanced technologies, law, ethics and governance, in fact reflects the trinity of the forces and more particularly the purpose for which this glitter is there. I will talk some with respect to my own subject, that is judiciary. At present, sir, we are at the crossroad, and we are in the change. We are at present at the transitional stages from conservative approach or the things which were going on. We have shifted now. We are thinking and talking about the use of AI, artificial intelligence, in the judiciary. We have started live streaming. We have started digital use of digital platform. For all these things, for the betterment of the justice delivery system. But these transitional days are concerned, we have to be very cautious. You see, when in the economic legislation it is said that it is always, there is a trial and error. And you should give some time to the economic legislature to work. Similarly, we have to give some time for use of AI before we accept everything and wholly the AI. AI has their own, you see, advantages and disadvantages. When judiciary is at present burdened with pressure of work and arrears and all these things, and people have to wait for number of years to get the ultimate justice, because our system is trial court to high court to Supreme Court. It takes time, correct? And the workload which is there with the judges, honorable judges, correct? We know what are their problems. And despite 24 hours, because everybody, every judge is a human being. Every judge has 24/7. We have to work with this 24/7. If the capacity, everybody's capacity is 100 meters per day, correct? And see, in Supreme Court and all the other things, my learned brother is there now. He knows the problems and how the system works, correct? In other countries, correct, they have 100 meters per year. We are having 100 meters per day. And we are disposing of and we are considering everything, correct? And giving full justice to all. We cannot do justice hurriedly, because it is said that justice hurried is justice buried. We believe in actual delivery of justice to the needy person, to the common man. He should not feel that I have some injustice is done to me. And that is why the use of AI will certainly help the justice delivery system. Use of AI will speed up the functioning of the courts, but at the same time, there are drawbacks also. Drawbacks are that when AI use is there, there is no human approach. The AI works mechanically. They applies whatever is there, whatever you feed, correct, the result will be there. There is no outside other feeding, applying the mind by the AI. Suppose some human approach is to be given. Like Supreme Court, we have got Article 142. Article 142 powers can be exercised by the Honorable Supreme Court to do substantial and complete justice. Where the AI will use this power under 142? Because there is nothing like substantial justice or complete justice so far as AI is concerned. Suppose some criminal activity, some criminal offense has been committed, and there is a discretion to be exercised in giving punishment or sentence. Correct? What he will do? AI will consider only, murder, correct? This much life, nothing then, less than that. But attempt to murder or all other things or some other offense also, where the punishment is between 1 year to 10 years. how AI will work. There the human approach or human application of mind is required. So all these disadvantages are there, but at the same time, correct, there are advantages also. We have to accept what is the best, correct, because there is always, correct, best in everything. You have to find out the best and you have to use it. And for that purpose, there is a training is required. You have to accept it before experiencing it. If you reject it, then you will not achieve the result. And that is why a training or summit like this is required for the purpose of actual understanding the technology. There are misuse also of the AI. There is a data privacy problem also. There are other things also. And even digital platform also, the cyber crimes are there, correct? And many things, correct, these digital platform are being misused. I was heading the that commission, not commission, but advisory platform, and for regulation of cryptocurrency in India. I chaired the session, and we have given the report to the government also how to regulate it. But difficulty is this, that this cryptocurrency, for whatever reason, correct, it is being misused, correct, and it is used for some other purpose. If it is regulated, correct, or it is used in a proper way, correct, then it will enhance the business. It will enhance the confidentiality and credibility. So that is why, correct, this regulation or this summit will today help. 3-day summit, correct. I would have come yesterday also, but there was some other commitments also, so that I could not come yesterday. And I heard that Justice Mehta is there, so I said, okay, readily agreed that I can meet him and discuss him some other also. Now, as I said that at present the judiciary is at the crossroad, accept, not accept. The advantages are also that because of the, I will give you the example of live streaming. Live streaming, there is a transparency, correct? Transparency means even a client from a remote village can know, correct, what is happening in the Supreme Court in my case. There are some funny things also. I can share you also. Yesterday, one of the Honorable Supreme Court judges shared with me on the dais. I would like to share with you also. There was one counsel. He appeared. He's a good counsel. He was appearing in the Supreme Court. When Supreme Court, all judges come ready after reading it from the home, so that we can save the time. All 100 matters yesterday, one day earlier, it reaches their residence, they read it and come. So after reading, they made up the amount that, oh, okay, this is a case for notice and grant of stay. So before the council starts, the order is passed, notice stay. Another matter was called out. Then again, he said that, okay, without hearing him, the notice and stay, because there was a point in the matter. After 2 days, the council said, no, sir. I think, I don't know whether you recollect or not. Because I think before his bench, he said, no, sir, please hear me 2 minutes. Because, sir, what is this? Then, sir, last 2 days, you issued the notice and stay without hearing. My client has said, you have not done anything, please return back the money. Then the bench heard him for 1.5 hours, and ultimately matter was dismissed because there was no substance. So she said, sir, I told you to hear me for 2 minutes, not for dismissing this. So these are the advantages and disadvantages of the system also. But ultimately, the client could know from the remote village that what is happening in my, what has happened in my matter. These are the advantages and disadvantages. Disadvantages also there, advantages are also there. Suppose for research work, I always use the digital platform for research, but not for the purpose of making the mind. Some judgments are needed, some literature is required, some history is required, how the litigation started, everything it will come in 2 pages. This is how the advantage and disadvantages of the system, the digital system, and this AI use. Thank you very much, sir, for giving me this opportunity, because we have to hear the sitting Honorable Supreme Court Judge Justice Mehta on the subject. Thank you very much, Bandari ji, for giving me this opportunity and to be here with all of you. Thank you very much. Bharat Mata ki Jai. Jai Jai Garvi Gujarat.
Much grateful, sir, for your insightful thoughts on the role of AI in Indian judiciary. And definitely AI is emerging as a great administrative assistant to help the judges and the entire judicial ecosystem. Thank you so much once again. And now, may I request Honorable Justice Suraj Govindraj ji to deliver the special address. Justice Suraj Govindraj ji is a judge at Karnataka High Court. And sir, we are so privileged to have you here. Thank you so much.
Good morning, everybody. Justice Sandeep Mehta ji, our Chief Guest and Judge, Supreme Court of India. Justice M.R. Shah and Honorable Justice A.K. Sikri, former judges of the Supreme Court. Honorable Professor Upendra Bakshi ji. Mr. Tony Moroni from Ireland. Our distinguished international scholars, practitioners. When I saw the list, it was from Germany, France, Switzerland, Portugal, Australia, Nigeria, Spain, Canada, and the United States of America. That's quite a list of countries there. Professor Dr. M.K. Barnari and the entire Galte family, distinguished speakers and all delegates present here in person and online. Namaste, good morning to you all. 3-day summit is quite a lot, but at the end of the 3-day summit, probably what will happen is when the summit closes and the delegates disperse to their respective countries in the regular work, each of you and each of us will carry with us the weight of a question that has no simple answer. As mentioned by Justice Demasa just now, how do we govern a technology that thinks, predicts, decides, and acts at the speed that no court, calendar, no legislative session, and no regulatory body can match in real time? The speed, as Mr. Bandari mentioned, is now in quantum computers. It's in qubits. So that is the speed. A palm-sized chip will be more powerful than all the supercomputers in the world combined, which probably comes in 2029 or 2030. Along with it comes artificial general intelligence. So both of them combined will be a double whammy. That is the question at the heart of ATLEG. I am grateful that Galte has placed this question for consideration by the brilliant minds that are here and who can come up with some solutions or some thoughts on how to take it forward. Many of you are technologists, but I speak as a judge. And when I say that, I mean quite specific. I do not speak as a technologist, though sometimes in today's world I have to become a technologist. I do not speak as a policy architect. Again, sometimes I need to become a policy architect in today's world. But generally I speak as a person who sits in a courtroom, reads pleadings, hears argument, writes orders, which has an impact on a human being or a corporation. Even as a corporation, on the human beings who are shareholders, etc. of that company. So the effect of that order is on human beings. Would AI be in a position to handle that situation? As Justice Emasha just mentioned, if it's a punishment from 1 year to 10 years, can AI decide that? Or can AI help in decide that? AI may not be able to decide it, but help definitely it can. But technology whose governance the summit is addressing, law, ethics and policy, is now entering that courtroom, or in fact has entered the courtroom. It's not waiting for any of us to be ready, the regulators or the judges to be ready. It has already entered. It has arrived in the evidence placed before us, in the tools used by litigants to prepare their cases, in the systems deployed by police to investigate crimes, in the algorithms used by financial institutions whose disputes we adjudicate. As somebody was saying, now it will be borderless finance. In the algorithm, and increasingly in the case management infrastructure that administers the courts themselves. The summit's programs are quite exhaustive. They are remarkable, spanning artificial intelligence, ethics, data protection, cybercrime, autonomous vehicles, liability for it, tokenized assets, quantum cryptography, deepfakes, fintech governance, legal education, and access to justice. There is a coherence in all of these. It is not that these are all diverse topics. If there is an issue, if there is a liability, if there is a accountability which has to be put in, that is through the legal system. The legal system essentially would also end up with the judiciary. So in that coherence of these aspects, how do these aspects get regulated? Do I know what I have to do? Do I know what I don't have to do? Both the do's and the don'ts become very important. That is the policy framework which will come about. And that policy framework in terms of regulation and how to deal with those matters is what also would probably be debated upon. I would love to read the final conclusions by the committee and the rapporteurs who may give us a write-up on that. From a judicial standpoint, this creates three distinct challenges that I would briefly identify. The first is the challenge of evidence. Today, a deepfake is as good as the original. That is why it is a deepfake, because you are not able to identify whether it's a fake or it's a fraud or it's a concocted document. Normally in our judiciary, we would one of the parties would always say it's concocted, fabricated. And it's easier to identify whether that signature is a forged signature, the document is a concocted one in terms of the stamp paper being a fabricated one, etc. But with a deepfake, it could be any of your voices which could be a deepfake, it could be a face which could be a deepfake, it could be metaverse, it could be situation has come to a place where there are sensory metaverses which have developed. In the sensory metaverse, groping has become an offense. Groping on a metaverse, would it be an offense? You would normally think on the internet there can't be, but we have had cases in London, we have got movies. Movies are essentially what I would say is when a human being, whatever a human being conceives and imagines, it becomes a reality. Movies are the precursor. And in that background, what I would say is with AI, we would want an iRobo, not a Terminator. So that is the baseline that I would draw. AI-generated evidence is not merely an academic exercise, it's a question that will come before courts in India with rapid increasing frequency. Our law of evidence was built for a world of document and witnesses. It is being tested by a world of synthetic realities. And those synthetic realities will become a difficult question for all of us to answer unless we come up with a regulatory framework. The second challenge, as I mentioned earlier, was accountability. When an algorithm performs an action, who answers for the outcome? The programmer, the deploying institution, the regulatory authority, autonomous vehicles, ADAS 4.5 or ADAS 5, it can drive by itself. It could be automatic trading. If there's a loss in automatic trading in the fintech sector, who is going to be responsible for it? I may just switch it on and say, you go on trading. Who will be responsible? Autonomous vehicle, who will be responsible? These conversations would have to have a polycentric governance on black box accountability, and on the free AI model of regulating AI-driven finance would have to engage directly with this question. The answer will define the liability landscape for the next generation of litigation, because we are past the old method of litigation of property matters or injunction matters. Those we'll have cyber frauds, we'll have a large scale reach from Jumantra to across the country. It is not restricted to any particular location or jurisdiction. We have cross-border jurisdictional issues also. The third challenge, this particularly for us, is the judicial independence. I say this carefully because it is a challenge I feel most acutely as a sitting judge. The moment we introduce AI into the decisional process of a court, even in the form of research tools, draft opinion generators, or case outcome prediction systems, we must ask, where does the judge's reasoning end and the machine's suggestion begin? Would it be a subliminal suggestion by the machine for a judge to follow? Or is it something that the human in the loop concept would have to be applied for us to work on? Judicial independence is not merely independence from the executive or legislature, it now adds a third dimension of independence from the architecture of inference that a privately designed algorithm in a black box suggests what could be the likely outcome. And if you even ask ChatGPT, could you give a different outcome with a different reasoning, it would give you that. It depends on what the prompt is. Do we become prompt engineers as such? If you say, these are the facts situation, I want a judgment this way, it would probably give it that way. If you wanted to give it the other way, it would be given that way. And both of them read very well and very coherently for us to be enamored by it. And what is the distinction that we draw there? So this independence must be protected by design and not merely by aspiration of speed. Justice arreed is justice buried is what we just heard, and that is practically true. India stands at a particularly consequential inflection point. We are a nation of 1.4 billion people with 25 high courts, around 20,000 district courts, and a pendency that makes technological efficiency not a luxury but a necessity of justice. Can any of you guess what is the number of litigation which you filed before the district courts from 1st January 2015 to 31st December 2025 in a block period of 11 years? Any guesses? 100 million, 10 crores. For those in India, 10 crores. For the others in different jurisdiction, we'll use million at 100 million, 10 crores. Any other guess? 5 crores, 50 million. Once, twice. You are not supposed to answer anything. Because we did have a conversation on that and we did say that. To remove the suspense from it, we had around 16 crore cases which were filed. That is 160 million for you in millions. So that is the magnitude of litigation which was filed in the last 11 years. And last year itself, it was 2.47 crores or 24.7 million cases which were filed across the country. The litigation which was filed in 2015 was 1 crore per 10 million per year. Now it has gone up to 2.47, which is just increasing. Can you guess how much were disposed of those? More important question, right? 10%. Very good faith in judiciary you have, sir. Then you should have better faith. 10% would make it 1.6 crores. To just give you this one, we have a pendency of 4.37 crores. I'll come to the pendency a little while later. 4.37 crores is what we have as a pendency. So, of course, 1.6 could not be the disposal. It should be much higher. Any other guesses? 75%? Now more faith in the judiciary. Anyone else? 50-50. That is taking the diplomatic route. Okay. We have disposed 14 crore matters. At 87% is the disposal rate. So when you are answering these issues, the fundamental foundation of the numbers are very important for you to think of before you suggest things that could be the solution. If we think of only 5 crores to be the filing or 10 crores to be the filing, we'll be mistaken. And the filing is increasing. It was 2.47. Now, 4.36 being the pendency is again a misnomer in the sense that 4.36 includes 2.47, which was filed last year. The moment a case is filed, it is treated as pendency. That is the unfortunate system that is there. So the day if a case is filed cannot be the pendency of it. So if we remove 2.47 out of it, it comes to rest around 1.8 to 1.9 or 19 million. So that's not bad at all. But the fact remains that it is pending. How do we tackle it? Could this 15% difference in 85 to 100% filing, or could we tackle the pendency by coming to 110% to 120% by AI, machine learning, adding to that 25% disposal? We are not looking at 100%. That 25% is good enough to reach where we have zero pendency or reducing pendency over a period of time, and we can tackle it. The Supreme Court has already published a white paper on the deployment of artificial intelligence in courts. SUAS, the AI assistant translation system, is operational. In fact, to give you another data, we have 37,000 judgments which have been translated into Hindi. Around 50,000 judgments of the Allahabad High Court have been translated into Hindi. Otherwise, most of the other states have had around 60,000 cases which have been translated into different languages, which are available free of cost on the ESCR. So a person who has affinity to a particular language, his mother tongue or the regional language, would be in a position to read that judgment, understand that judgment in his own or her own personal language, which strikes a chord with that person, because some of the nuances of the English language may go unnoticed to that particular person. So that being the case, these issues would have to be looked into. DPDP Act, AI, the regulations of all these things, the cross-border data, so many issues have been put forward. If these could be looked into and a paper presented as to how to take it forward, it would be a great achievement. All the best to you. Thank you.
Thank you so much, sir. Thank you so much. Thank you for raising all the important concerns, issues, challenges, and also sharing your experience with us. And we do definitely have a very strong faith in Indian judiciary and in all of you. Thank you so much. Now it's a pleasure for me to introduce the speaker for the keynote address this morning, Mr. Tony Moroni. He is the co-founder and managing partner for EMEA at Axis CX and principal at the Digital Explorer. He has served as Senator for Ireland at World Business Angels Investment Forum, affiliated with the G20's Global Partnership for Financial Inclusion, and also a faculty member at the Institute of Bankers in Ireland, delivering programs on digital disruption in financial service and fintech. So we welcome you and invite you to deliver the keynote address of the Galto Mega Summit on ATLEG. Thank you.
Good morning, everyone. Tony Moroni, absolutely delighted to be here. My first time in India, and thank you, Dr. Bandari, for the kind invitation, but also to all of you who've made me feel so welcome. I'm not a lawyer, I'm not a judge, and I'm not a technologist, so you might wonder, why am I here? I work with businesses all over the world in the space of disruption. And one of the biggest issues that we have is that this phrase, digital transformation, immediately puts us in the wrong frame of mind, because we're not technologists. Everything becomes about the digital. And in reality, actually, the technology is secondary. It's not about the AI, it's not about the blockchain, it's not about quantum, it's not about any of those things. It's about, what does this mean for our businesses? And if it's important to our business, it also means, well, what does it mean from a legal perspective? What is it that we need to be thinking about as our organizations move forward? So today I'm going to talk to you about AI, not from the perspective of transforming the technology, but from the impact it has in terms of accountability. And we heard this already this morning in terms of, well, actually, who is accountable? Because if machines are making decisions, well, what does that mean? So I want to put it a little bit in context first, see if this works. Yeah. Oh. Yes, it's working. So we're hearing all this talk about AI and all the wonders that it's going to do. But in reality, we have spent 3 decades or more on digital transformation. And yes, we've improved certain things. We've got some efficiencies, we've got some more insights, all those type of things. But in reality, you know, have we got the type of change that we expected? And the answer is no. And it depends on who you talk to. You know, the failure rates or the ability to deliver results has failed by 70 to 80%. And it's not because of the technology. The technology does what the technology does. But what hasn't changed sufficiently enough is our business models, particularly in relation to decisions. And what I see all over the world is, we take a new technology and we overlay it onto our organization, and we keep everything else the same. Now, I don't know about you, but you know, I don't think that's going to bring about the type of change that we can expect. So, one other thing, and it was mentioned already in our speeches here, is that this is not a passive technology. So it starts to raise another important, really important question. And it's not a technical question. It's a business question, it's a governance question, and it's a legal question. And that question is, who is responsible when decisions are no longer truly human? And what we really need to think about here is that AI is not about automating processes. It's about automating decisions. It's also changing where does intelligence sit in the organization. Because historically it sat at the top of the organization, or at least our leaders would like us to think it was at the top of the organization. Certainly the organization chart mandated that. But we're now moving into a space where technology is making decisions, so it's no longer about optimization. It's about delegating judgment. Because the technology is learning, adapting, acting, learning, adapting, acting, and pretty soon we're not quite sure what the technology is doing. So it was already referenced in terms of black boxes, etc. But it also means that it's moving from being an assistant to actually have an agency. Because if the technology is making decisions, to my mind, it has agency. And if it has agency, it therefore is an actor in the organization. And that raises a fairly fundamental question in terms of, our organizations, are we blindly, or as there is a phrase called willful blindness, are we not acknowledging the fact that decision making is changing? Because if responsibility is changing, right, because if the decision authority moves, well, responsibility moves as well. And that means accountability moves too. And if we ignore this, we have the beginning of systemic risk in our organizations. And I can guarantee you that we will have a situation in the future where, in front of our honorable judges, directors will be saying, we didn't realize the technology did this. And that won't be an acceptable reason for why things went wrong. As with all things, our organizations like to have this sense of control. So, we have AI now. So let's have better dashboards, let's have more oversight, let's have better governance. And all of these give a sense that we are in control, but are we actually in control? Because dashboards that give us more data and more insights, but less comprehension perhaps, doesn't mean we understand better what's happening in our organization. In fact, we may not know what is happening in the organization. We may not even know the decisions have been taken. Oversight, great. So we're looking at outputs. But that doesn't mean we're accountable for the outcomes, unless we're clear about it and we're intentional about it. And governance. Does governance mean responsibility? Well, if no one owns the consequences, because it's unsure who actually made the decision, well, is our governance framework really working? And this has been mentioned already. If we have AI acting in our organization and we have no traceability of why or how it happened, that is not governance. And, I'll defer to the people behind me, but, the courts are not going to evaluate your dashboards. They're not going to evaluate your intention. They're going to look at the decision. They're also going to look at, well, who made the decision, and perhaps even who should have made the decision. So dashboards, great. Oversight, great. Governance, fantastic. But is that really what we're doing? And these are real questions that we must address. I'm sorry, my ticker is a little slow. So, this one. So, when we think about accountability, we tend to think about authority, judgment, accountability, and control. And we've been using these sort of tenets for the last couple of centuries. But AI starts to fundamentally challenge each and every one of these. So authority. Authority usually came from, the person with the most experience, they had the position in the organization, etc. But what if authority is increasingly challenged by AI. Because humans are deeply flawed, in case we didn't know it. We're deeply flawed. And in the main, we operate with, sufficient information, so we satisfy. AI can operate with full information. So what if accountability starts to be challenged because the technology actually is making better decisions? Judgment. All our great leaders like to say they have great judgment. They understand the business. They can see the trends. They can spot the anomalies. What if AI is doing that better, doing it 24 hours a day, 365 days a year? And what if the board is looking at the simulated judgment of technology versus the actual judgment of executives and starting to question it? Accountability. Well, accountability, to my mind, suggests someone made a decision. So it comes back to the core point. Who made the decision? Was it the person? Or was it the AI? Or was it a combination of both of them? And if it was, well, who ultimately made the decision? Right? So that brings us back to control then. Because in our organizations have moved very slow. And decision-making in our organizations has been traditionally very slow. Because it ran up the line, there was, committee meetings, review meetings, board committees, you name it. So there was all these opportunities to intervene and shape the decision. But what if that's compressed to a nanosecond? So there are no reviews. The technology makes the decision in the moment. We no longer have the ability to intervene. So when we look at this, we need to be sort of saying, well, our whole premise of how we run organizations needs to change. Because otherwise we have some serious challenges. But the other thing it does is it starts to, and you mentioned earlier about the car, right? So one of the big issues on the car, as I understand it, is, well, who's responsible if the autonomous car goes wrong? Is it the car maker? Is it the guy who wrote the algorithm? Is it the person in the car? Was it the council who had your car on the road? Who's responsible? And if we look at our organizations, now what we have is we have developers building models, training data. We have operators putting it into deployment and running the business with it. And we have the organization itself deciding on what basis it can operate and what the risk appetite should be, etc. So we have shared responsibility, which means we have distributed risk. But actually, if we're not explicit about this, well, then we have no responsibility. And the issue we face then is, if this becomes unclear, actually our risk and our liability increases. So one of our major challenges is, because all this is happening at such a speed, our leadership and our governance models are struggling to keep up with machines that operate at machine speed with machine logic, not human intent. And that's a real challenge that we must address. So we're in a new era. We have decisions delegated by default. And this is happening in our organizations today already. It might be happening in small places, but it's happening. Right? Even if it's as simple as getting ChatGPT to write the letter, it's happening. So we're starting to delegate by default. We're no longer thinking for ourselves. We're just letting the machines do things. And what happens is that we start to rely on these machines, and we no longer start to question them. And so we're not questioning them, we're blindly following them. And most importantly, we're now getting the evidence after the fact. So we're now getting evidence after the impact. So before, we operated in an environment where we could look at something and sort of say, well, if we were to do that, what might the impact be? How might it create risk in the business? How might we mitigate those risks? Now actually what we're getting is evidence after the event. So the machine has done something and maybe compounded it, and maybe we didn't even know for 9 months until we find we have a problem with all of our customers. And we're now dealing with the evidence after the event, and we're trying to justify or make sense of it which is not a place we want to be. So we need to reframe governance. It's no longer about controlling individual outcomes. This is about responsible systems. So just as we try to govern for behaviors in our organization, we need to start governing for behaviors of our technology. So we need to start thinking about, well, what is happening and how are things manifesting and why is it manifesting that way? And look, I hear a lot of talk about humans in the loop. From where I sit, or stand at the moment, that's too passive. It needs to be humans in control. Because I am sure if you go to the courts and you say, well, actually, we had humans in the loop, they'll be looking at you sort of say, yeah, but how did that impact the decisions? So we need to change our whole perspective, and we need to start looking at this in terms of the architecture, in terms of the intent, and in terms of the overall outcomes that we're achieving within the business. So if we work on the premise that, look, we've always worked with leadership being intelligent, making the decisions, and that premise is gone. The question that I want to leave you with is, when intelligence is no longer human, what does accountability become? Because to my mind, the greatest risk is not that the AI fails, is that accountability gets distributed and we have no idea what is going on. Thank you.
Thank you, Mr. Moroni, for sharing your insights with us, very important insights with us. And now it's time for some special addresses, addressed by our esteemed guest of honor, who has shared his recording with us. He couldn't come here and join in person. Honorable Justice A.K. Sikri. A brief, he doesn't need any introduction, but still Justice Sikri has been an eminent Indian jurist, is an eminent Indian jurist and a former judge of Supreme Court of India. And he's also been an international judge at the Singapore International Commercial Court, Singapore Supreme Court. So we are so thankful to him. And he is also a Galtarian. That's an important introduction and a new feather to his cap. So may I please request to play his recorded message.
I extend my warm wishes to all of you who have gathered here today, all delegates and visionaries in Hyderabad for ATLEG 2026. At the outset, I must thank Professor Bhandari and his team for giving me this opportunity to address you all. For certain reasons beyond my control, I have not been able to join all of you in person, even when it was my earnest desire to be there amongst you and enjoy, or I will say not only enjoy, but gain a lot of wisdom also in this 2 or 3 days event which has been organized. I must also express in the beginning itself that I have come to know Professor Bhandari very recently. Earlier we had met, but not that closely. And I admire his dedication, his commitment for the cause, his hard work which he puts in for everything which he organizes. And that applies to this particular conference also. The way he has been following up, the way he has been making the arrangements, as I could see, for this particular event, which is very significant event, it is really remarkable. And it not only impresses us, me particularly, but I would say it has inspired me also. That yes, if we have to undertake some task, it should be with the same sense of dedication as Professor Bhandari has shown. I have come to know about GALTER also, that is Global Academy of Law, Tech, Education and Research, very recently. I have now become a member of GALTER, and the service, I would say, to the society, particularly legal community, which it is providing, as the name suggests, Global Academy of Law, Tech, Education and Research. So in law, tech, education and even research, I mean, the service which it is providing is really tremendous and has to be much appreciated. And I congratulate GALTER for convening this ambitious summit at such a critical juncture in our technological evolution. Why I say so? As I have seen, the theme of this particular conference is Advanced Technologies, Law, Ethics and Governance. It is no longer a matter of academic speculation. As we know, the manner in which the technology is developing and making inroads into our daily life, including in the field of law, it is no more remains an academic speculation. It is the front line of modern governance today. Delhi, a couple of months ago, had hosted in AI summit, World Summit, and the participation of most of the countries in that summit, and CEOs and chairpersons of very big multinational companies who are all here in Delhi, is a testimony to the importance of technology in our life. And same applies to law as well. We are witnessing a transition from the era of lex, that is law, to the era of lex informatica, as algorithms begin to influence everything from judicial outcomes to socio-economic opportunities. We must ask ourselves, how do we preserve the human element in an automated world? History teaches us that technology moves with velocity, while law moves with deliberation. However, the gap between the two can no longer be a chasm. To ensure the rule of law does not become the rule of code, we must infuse our legal framework with, and I highlight some of the points. Number one, proactive ethics, designing systems that are ethical by design rather than as an afterthought. Next, algorithmic transparency, ensuring that the black box of AI remains open to judicial scrutiny. And it is very important, as we have been seeing some of the issues which AI is raising as far as judicial or legal functions are concerned. And I think there would be a lot of deliberations on this in this summit during this next 2 days. Then I also highlight global synchronicity, recognizing that technology knows no borders, and neither should our commitment to human rights. Artificial intelligence, blockchain, biotechnology, autonomous systems, and big data analytics, fintech, metaverse, and quantum computing are reshaping every facet of human existence. How we work, how we communicate, how we access justice, and even how we understand our own humanity. History teaches us that technology moves with velocity, while law moves with deliberation, which I have already mentioned above. And therefore, I organizing such a summit in these times, I think it's something which, as we say, the idea whose time has come. We need deliberation on various aspects which are going to be discussed, deliberated, and pondered over
Sir, there is no
by
sound.
various
Can't listen
speakers
you.
who are going to speak on these subjects, and all the audience who is going to attend. There would be useful deliberations, and therefore for doing organizing such a summit, it serves as a beacon for responsible innovation, reminding us that technology must always remain a servant of humanity, not its master. And that is the central theme of this particular summit. And I am very, very, I think, and I am very sure that the deliberations would be very useful, and the ideas which come out from this summit will be shared with the policy makers, so that we are able to achieve rule of law and do justice to the society. Even with this technology becomes support for achieving rule of law and justice, and it should not become an obstacle. And at the end, I also must say that must add to this at this Galter that there are two outstanding teachers who are going to be felicitated as the teachers of the year, who have been given this award. Again, thanks to Professor Bandari, who reached out to me and asked me to be the chair of the jury, consisting of two most eminent teachers, including one, Professor Bakshi, who was my teacher as well, and Professor Jaswal. We chose these two persons, and I am very, very, I hope that this is, our judgment is appreciated, and I congratulate Professor Rajkumar as well as.
Thank you. For some reason, it got stuck. Honorable Justice Sikri was congratulating the awardees for the day, and we'll be coming to the award ceremony in a little while. We are, all the Galterians, we are very much grateful to him for sending his recorded message and also for blessing us for the occasion. So a big thanks to him. And now it's time for another special address, as Justice Sikri mentioned, by his professor, by Professor Upendra Bakshi, the most distinguished professor we have known. He is a legal scholar since 1996, professor of law in the Department of University of Warwick, United Kingdom. He has been the Vice Chancellor of University of Delhi, prior to which he held the position of Professor of Law at the same university for 23 years. He has also served as a Vice Chancellor of the University of South Gujarat, and in 2011, most important to mention here, he was awarded the Padma Shri, India's fourth highest civilian award. Professor Bakshi couldn't come here because of the health issues, but he has been very generous enough to send us a detailed note on the theme of the summit, as well as a recorded video message for all of us. So the detailed note will be shared with all the Galterians later in the soft copy. Can we please play his recording?
Have you in this inaugural session as guest of honor. Your blessings are always available in abundance to all the Galterians. I request you to kindly record your address as guest of honor, which we will play, and also I will read out the special address and note you have shared for ATLEG 2026. Over to you, sir.
Thank you, Dr. Bandari. It is very nice to be with you all, and it's very kind of you to ask me again for this great conference. I again greet you all very much. I have not much to say excepting I want to add something. I've already said plenty of minuses about AI in my speech, which I hope people will read. But I just came across something new, which I think I should share with you all. It's too early to say that we are witnessing a birth of a human rights oriented AI or even a constitutional AI. It's too early. But my attention was drawn recently to a firm called Anthropic. Anthropic is a toy dispute with the government of US. And the Anthropic is making many products, including a program called Claude, which is very popular. And it has some contracts with government of United States, Defense Department. And it insisted, fortunately, these AI companies rarely do it, but it insisted on, I quote, strict red lines. And what were the strict red lines? These were meant, this clearly said that the programs of Anthropic should not be used, and I quote, for unrestricted surveillance or autonomous weapons, unquote. This is extraordinary. So far, no supplier in a global supply chain of military hardware or cyber warfare computer has dared to lay down certain red lines in government defense contracts. And the government, of course, the Pentagon, the White House, has demanded a total use and access for national security purposes without any restriction, and has in fact said that it is not the responsibility of the contractor to decide or to advise on how warfare is conducted. It is responsibility of the state to consider all defense matters. A mere contractor, a program supplier, a cyber warfare supplier, or a hardware supplier is not supposed to lay down conditions. But what is extraordinary is that Anthropic has insisted on this condition. It has also now filed lawsuits challenging the idea that the state can do anything it likes as far as defense is concerned or as far as warfare is concerned. This cannot be a matter of a private contractor saying how defense matters will be conducted. Not content with registering a protest or drawing some red lines, Anthropic has now gone further when it heard the Defense Department protest and filed lawsuits in America challenging the government or the state. This is unusual, and this sets up a major precedent. And therefore, I do think it's too early to speak of human rights or as you say, humanization of AI and so on by commercial companies. But this is one example which proves Dr. Bandari, your idea of humanization. This is one example where humanization of AI programs, even in matters of defense, the private AI company is drawing some lines that you cannot use it for mass warfare. Or you
Yes, sir.
cannot use this category more precise. One, you cannot use the program for unrestricted surveillance, and two, for autonomous weapons. These are two guidelines, red lines
Yes.
that were drawn. And now it's a matter of lawsuits as to a very, very interesting lawsuit because the problem gets complicated if you state the state as an ethical agent, a
Yes, sir.
moral agent. If you
Uh,
have a negative view of the state power as a amoral, anything goes kind of thing, then of course it is not a problem. But if the state is an ethical agent, is to be considered ethical agent, it can say to a supplier of hardware of any kind, soft or hard, that a mere contractor cannot determine
yes,
what
sir.
uses the technology will be put to. But assume
Thank you.
that the contractor itself also is an ethical agent. So there are two conflicting moralities of the
Yes,
weapon
sir.
supplier and of the state, which should prevail.
Thank you, sir.
Thank you. We are much grateful to Professor Bakshi. He's a legendary figure when it comes to his role and contribution in the development of legal jurisprudence. So we are grateful to him not just for addressing us today, but also for his remarkable contribution to legal jurisprudence. Thank you. And now, moving on to the next section, it's time for acknowledging some very important academic and research contributions with the beginning of the release of ATLEG souvenir. The souvenir has been beautifully prepared and designed by Ms. Priyanka Vedanath and Advocate Vipin Raj. May I request to bring the souvenir on the stage and request all the dignitaries to release the same. The souvenir contains all the abstracts of the papers which have been presented and will be presented during the 3 days of the Mega Summit. I also request Priyanka to join us on the stage and say a few words about it.
Thank you very much. A very good morning to all the dignitaries on the dais and off the dais and fellow Galtarians. The ATLEG souvenir has messages from 13 eminent jurists who are also present amongst us today. And also about 50 plus abstracts that were shared by the legal academicians, industry experts, research scholars and students. I hope all of you had the souvenir and you can see it firsthand about their contribution to the ATLEG summit. So many thanks to all the Galtarians and others who have contributed, and my special thanks to Vipin who helped in the processing of this souvenir. Thank you so much.
Thanks, Priyanka. And now it's with immense pleasure and pride that me personally, as well as all of us together, all the Galtarians today, celebrate a very significant milestone. It's a book being authored by our professor, Professor M.K. Bhandari. So it's time for the release of the book, titled Emerging Technologies, Application, Regulation and Governance, published by Thomson Reuters. So before we release the book, may I invite Professor Bhandari to tell us about the book, followed by the release.
It is my pleasure and privilege to get this book released by our learned guest here. After making a lot of efforts and out of turn, Thomson Reuters has given me just 4 copies yesterday, 11 p.m. from Chennai, because this book was not listed in their printing schedule till April. But I wanted to take this opportunity, so they gave me only 4 copies. Now after 15th of April, the book will be available. Just a minute. It is not the size of the book which is important, it is the contents which is important. The book is having 33 chapters, 12 appendices, which include the first white paper for Bitcoin by Satoshi Nakamoto. My friend George knows it. And then many other European AI Act, Indian DPDP Act, and many other international responsible AI, Digital India draft, so many. So I have covered till January 2026 the developments and advancements in the blockchain technology and fintech, metaverse, artificial intelligence, digital assets, and last one, the quantum computing. The second book, which is in process, is about the cyber security and quantum computing. Again, because quantum computing has been discussed not in a very much detail here. So I hope that this book will be one of the essential book for all those who are teaching law and technology in India at any stage. I thank Thomson Reuters for publishing it. Thomson Reuters needs no introduction, and it is an outcome of the 2 years of research and 7-8 years of my experience as a Galterian. And I must thank my wife Shobha Bhandari for sustaining my efforts, and all those my family members who have supported me in this mega project. So I am thankful to Honorable Sir for releasing it today, and the book will be available after 10-15 days. I'm sorry, I have only 4 copies with me, so we all will release it here, and I'll share the link with all those who want to buy it. They will get as a special 40% discount on this book, as the Thomson Reuters has said me that you can share the link, and initially 30-40 days we will offer 40%. Normally we offer 20 to 25%. Thank you very much.
Thank you, sir. So, ladies and gentlemen, this is the release of the book titled Emerging Technologies, Application, Regulation and Governance, published by Thomson Reuters and authored by our eminent Professor Dr. M.K. Bhandari. Please put your hands together for the release of the book. Thank you very much. And now it's time for the release of another important literary contribution, which has been contributed by Galterian Dr. Shobha Bhandari. May I request Professor Nishtha Jaswal and Mrs. Vibha Bajpayee to come on the stage and release the literary poster, which portrays the amazing literary contribution by Galterian Dr. Shobha Bhandari. Ma'am, please. Before we release the poster, may I request Dr. Shobha Bhandari to felicitate Professor Nishtha and Mrs. Bajpayee by presenting a shawl to them. So more power to women. Ladies and gentlemen, please put your hands together for our three eminent women and female power here. Thank you so much. Dr. Bhandari, it's my pleasure to introduce her briefly here. Dr. Bhandari holds a doctorate in English literature and she has also graduated in Hindi literature. She has a flavor of writing Hindi and English poems as well as short stories and articles, out of which more than 150 have been published in various national and international dailies and magazines. Within a span of 4 years, she has completed 17 e-books comprising 400 poems, bilingual, having all literary titles, kindly note, starting from the letter A. She has dedicated one of her collections entitled Abhar to her mentor and PhD guide, Professor Dr. Mrs. Kamini Dinesh, and one of her collection titled Astitva has been co-authored by Galtarian Dr. Sindhu Bhaskar from United States. May I request Dr. Bhandari to share a few words with us.
Feeling so blessed and overwhelmed for the honor on my literary poster comprising of 17 e-books plus 400 plus books, poems on Hindi and English languages. So I am extremely grateful to Dr. Madam Nishta Jaswal and Mrs. Vibha Vajpayee for giving me this honor. And I would also like to thank a lot to the lifeline of our Galtar family, Dr. Aparajita and Dr. Priyanka. Please come over the dais.
Thank you so much. And now it's a great honor for me to invite our chief guest for this summit, Honorable Justice Sandeep Mehta ji. Justice Sandeep Mehta ji is a sitting judge of the Supreme Court of India, and prior to his elevation to the Supreme Court, he has also served as the Chief Justice of Rajasthan High Court. Earlier, he was a permanent judge of Rajasthan High Court and had initially been appointed as an additional judge of the same court. It's an honor for all of us, each of the Galtarian here, to have you with us today and listen to your words. Thank you.
A very good morning to all. My esteemed elder brother, Honorable Justice M.R. Shah, or as we fondly call him, Mukesh Bhai, he has been a guiding light for me for a long time, and he had supported me through tough times. Thank you, sir. Dear brother Suraj Govindraj, my younger brother, his name justifies what he does. He is truly the son, the illustrating son, and illuminating the Indian judiciary with his knowledge and know-how on technology. He is one of the forerunners of how the system, the judiciary, is developing on all fours in adaptation of technology. I have learnt a lot from him, I must tell you. My esteemed teacher, Professor Dr. M.K. Bhandari, Tony, the Vice Chancellors present here, members of the academic and legal fraternity, senior advocates, gracious ladies and gentlemen, and dear participants. It's indeed, first of all, I must tell you that it's really a daunting task now, that all these erudite speeches on by domain experts on this topic in which I am truly a novice, it's really challenging to speak here amongst this august gathering. But all the same, it's indeed a pleasure to be here today at the inaugural session of ATLEG 2026. This is a global mega summit hosted under the aegis of Walter, the Global Academy of Law, Tech, Education and Research. I feel truly privileged that Professor Dr. M.K. Bhandari Sahab has given me this opportunity to be a part of this occasion. This summit is providing a vital forum to address a subject which is of profound consequences to the future of law, both in this country and globally. Let me start with a small observation. We live in a world where artificial intelligence now makes decisions affecting millions, where data collection has reached an unprecedented scale, and where blockchain is fundamentally challenging how we trade. From agriculture, medicine, healthcare, national defense and law, automation using AI is becoming a part of our daily reality, or rather it has become part of the daily reality. In the face of such change, we must ask, what is the role of law here? What is our responsibility as those who serve the legal system? Most importantly, is the current legal framework keeping pace with these shifts? And the imminently burning question, how is dependency on AI affecting our justice delivery system as a whole? These are questions not merely intended to provoke, but to guide. They call for careful introspection and sustained engagement. It is in this context that institutions like Galter and summits like ATLEG assume great significance. They provide a space not merely for a discussion, but for informed and structured reflection on issues that are likely to define the future of law. Before I speak about the institution and the summit itself, I want to say a few words about the inspiration behind the event. Professor Dr. M.K. Bhandari, my revered teacher in law graduation. Dr. Bhandari was our professor, and his was one of the most sought after lectures during those evening classes which most of the law students invariably attended. It is rarely the case that the person who identifies a legal gap is also the one who undertakes the task of building the institution and the framework to address it. Professor Bhandari is one of those rare personas. Many scholars critique the law. Fewer take the additional step of creating the institutions required to engage with it. Professor Dr. M.K. Bhandari Sahab belongs to the latter, the rarer category. He is amongst the senior most professors of law in India, with over 4 decades of experience spanning constitutional law, intellectual property, and human rights. Within that long career, he chose to turn his attention to cyber law and digital governance, blockchain and cryptocurrency, long before these subjects had entered mainstream legal discourse. That was not the obvious choice at that point of time. It required both intellectual foresight and willingness to work in the areas where established frameworks were very thin and scholarly company was scarce. His decision to establish Galter represents something beyond individual scholarship. It is an effort to institutionalize a line of inquiry to bring together law, technology, and ethics within a single, structured, and enduring framework. Scholarship contributes to discourse, institutions sustain it. They provide continuity, they organize, they provide collaboration, and ensure that important questions continue to be asked even as the people asking them change over time. To Professor Bhandari, therefore, appreciation is due not only for his academic contributions, but for the effort to create an institutional framework that is intended to endure and evolve with time. My deepest felicitations to you, sir, for this event and for the wonderful publications which have been just now shown to the August gathering. And really, it's a matter of pride that Thomson Reuters has taken over the task of publishing your book. This is a remarkable achievement, I must say. The establishment of an institution such as Galter reflects an important recognition that the challenges posed by the emerging technologies cannot be addressed within the confines of any single discipline. Questions relating to artificial intelligence, digital currencies, or data governance do not arise purely within law. They engage computer science, economics, ethics, public policy, and constitutional principles simultaneously. These are interconnected issues and they require responses that are equally integrated. What is therefore necessary is not an isolated expertise, but sustained and structured engagement across disciplines. In that context, initiatives of this nature seek to facilitate dialogue and research aimed at developing frameworks that are both principled and workable. The emphasis on an ethico-legal approach is particularly relevant because innovation without ethical grounding remains incomplete, while regulation without adequate understanding is unlikely to be effective. The broader value of such effort lies in the continuity of intellectual engagement which it promotes. Though it is through sustained and collaborative effort that legal thought evolves and adapts to new realities. At the heart of this academy lies what is described as the Galter doctrine. As a student of law, I find its philosophical foundations particularly compelling. It draws its inspirations from Aristotle, who defined law as a sort of order, a comprehensive framework of rules that gives coherent direction to collective life. He saw law not as a set of restrictions, but as the organizing principle through which order and justice are made possible. That insight has endured through centuries of legal thought and it remains relevant even today. The Galter doctrine therefore applies that insight to the current situation. It holds that law and technology are not antagonistic forces, but two streams intended to flow together to energize and enhance each other. Law provides the normative framework, the values, the rules, and the accountability structures within which technology must operate. Technology provides the capabilities and the possibilities that law must learn to govern. Both, therefore, are engaged in the shared pursuit of order and human dignity, and both must remain answerable to the demands of ethics. What the doctrine ultimately asks of us is to see law as the ordering principle of a well-functioning and seamless technological society, one in which innovation is not left ungoverned and governance is not left uninformed. Now let me speak about the ATLEG 2026, what the summit seeks to achieve. The theme which runs through the conference, advanced technology, law, ethics and governance, could not have been more relevant and timely. Artificial intelligence, blockchain, virtual reality, biotechnology, and robotics are no longer matters of distant speculation. These are reshaping the way we work, communicate, trade, govern, and litigate. They have created opportunities for innovation and inclusion of a scale that previous generations could not have anticipated. They have also generated questions of legality, ethics, accountability, human rights, and social justice that are amongst most complex that legal thought has ever been asked to address. As societies move into an era of hybrid human machine ecosystem, the inadequacy of an existing legal structure is becoming increasingly difficult to ignore. Algorithmic bias, deepfakes, as has been referred to by my previous speakers, genomic privacy, and the growing concentration of digital power in the hands of few private operators. Mark my words, this is very important because every country is facing grave challenges because where the control lies. These are not hypothetical concerns. They are live problems for which current law in many jurisdictions does not have adequate answers for the present. Nations are beginning to converge towards global norms, but significant regulatory fragmentation persists. The need for a proactive, coordinated, and multi-stakeholder response has therefore become genuinely urgent. The sub-themes of the summit reflect that complexity. They span the reinvention of digital jurisprudence, digital rights and humanism in the digital age, intellectual property in an era of generative technology, responsible artificial intelligence, data protection and digital sovereignty, robotics and autonomous systems, fintech and digital assets, smart contracts, the metaverse, global data governance, and the regulation of digital markets. The expanse of the summit is well carved out and intentional because the governance challenges of a technology rarely stay confined within it. For example, artificial intelligence affects privacy, cybersecurity affects autonomy, blockchain affects financial regulation and consumer protection simultaneously. A summit that addresses these themes together rather than in isolation is making an important intellectual choice, the choice to engage with the actual interconnected shape of the problem. The objectives of ATLEG 2026 are practical, innovative, as well as ambitious, I must say. The summit seeks to foster global alignment on technology governance, to identify regulatory gaps, to develop ethical frameworks that policymakers and developers can actually use, and to propose governance models capable of evolving alongside the technologies they govern. It is designed to produce concrete outcomes, a global declaration on tech governance, a policy roadmap till 2030, white papers, and the foundation of a continuing multidisciplinary governance network. Friends, many conferences end with speeches. The value of this initiative lies in its attempt to end with structure, with outcomes that create institutional memory, policy continuity, and a network of people and institutions that will carry this work forward well beyond this vibrant week in Hyderabad. The establishment of a permanent global tech governance network is a crucial step in that direction. What is needed is not only innovative ideas generated at a single event, but a sustained institutional mechanism that monitors the developments, tracks the implementation of recommendations, and responds to new technological challenges as they arise. The choice of a hybrid format with participants present here in Hyderabad and contributors joining virtually from across the world reflects the spirit of what this summit is about. That knowledge should not be limited by geographical boundaries. When the subject is the global governance of technology, the conversation must itself be global and inclusive. Now, what is the judicial perspective of the conference? On a personal note, I must say that this kind of multidisciplinary forum is genuinely necessary. Courts, as everyone knows, are already being asked to interpret constitutional guarantees and statutory provisions in the context of technologies that earlier generations of legislators and judges did not anticipate. Mark my words, it is now already the provisions of section 65B or 63.3 of the Bharatiya Sakshi Adhiniyam, they are already being challenged. They were introduced just in recent past, and they are already facing challenges on applicability. Questions about privacy and surveillance, the legal accountability of automated decision making, as was discussed by Justice Shah, Justice Govindraj, the status of AI generated content, genomic data and its protection, the regulation of deepfakes, a huge challenge in day-to-day life, and the jurisdiction of courts over digital platforms operating across borders. These are already at the doors of our courtrooms, not as hypothetical cases, but as live matters requiring a speedy response. What makes this summit particularly valuable from a judicial perspective is its composition. It brings together not only lawyers and judges, but educationalists, academicians, biotechnologists, quantum researchers, civil society representatives, and senior figures from international bodies. This vast range of expertise reflects a mature understanding that no single institution or profession can address these questions alone. Now, I would like to say something about the role of the young researchers and the paper presenters in this conference, in this summit. What you have done in preparing and submitting your research is not a small thing. You would have engaged seriously with some of the most complex and consequential questions in contemporary legal thought. You would have dreamt of ideas, pondered upon the same, researched those ideas, formed arguments, and put your thoughts into a form that can be examined, debated, and built upon. That is the basic unit of intellectual progress, and it matters more than it may sometimes seem. Something is not made clear to the young researchers, that is, the ideas developed at conferences like this do have a way of reaching the places where the decisions are made. They find their way into legislation through the work of policy advisors who read widely. They find their way into court judgments through submissions of counsel who stay updated with academic scholarship. They find their way into regulatory frameworks through officials who are themselves once students presenting papers at summits like this. The rigor you have brought to this research process will serve you well when you encounter the challenges that artificial intelligence is already beginning to pose within the legal arena, and those challenges will come sooner rather than later. The legal questions that ATLEG 2026 addresses do not have ready or settled answers. The law around artificial intelligence is still in the process of development. The constitutional framework for data protection is still evolving, even though the act has come into force. But still, as it is said that law is dynamic, the process of evolution will continue with the challenges. The governance architecture for decentralized technologies is still contested. These are genuinely open questions, and the papers being presented here by the scholars and the emerging researchers are part of the process by which those answers are being worked out, everyone, each one of the participants is contributing to that process. My suggestion, therefore, to the young researchers, engage fully with the feedback which you receive here, because criticism is how ideas improve. Stay in conversation with the community that Galter is building, because the questions you are working on today will remain with you throughout your professional lives. Do not be discouraged by the scale of the challenge. Every generation of lawyers has faced a moment when the law seemed inadequate to the demands of the time. What distinguished the scholars and the practitioners who made a difference was not that they had all the answers. It was that they kept on asking the right questions with discipline and honesty. That is what this summit is inviting you to do. Law, all its imperfections, remains the most reliable instrument we have for organizing power in a way that is accountable and responsive to the values of the communities it governs. The task of making law adequate to the challenges of the digital age is demanding, but it is neither impossible nor unachievable. It is, in fact, the central legal task of our time. Institutions like Galter exist, therefore, to take on that task with the seriousness it deserves. To the scholars, the practitioners, and the students gathered here, my message is that your engagement with these problems over these 3 days of vibrant discussions carry significance beyond the academic discourse. The themes of this summit are not abstract ideals. They are the pillars upon which a credible and just regulatory future for technology must be built. Before I close, I must remind everyone that let us strive to a situation that artificial intelligence does not take over natural intelligence. I'll share one anecdote. I was doing a habeas corpus petition in the year 2000. It was a petition filed on behalf of a young mother seeking custody of her 3 months old child who had been snatched by the father. The matter came before the court, and after much arguments, the bench was not being persuaded. I told the bench, sir, you should use your own experiences as parents to look at the problem. The judges said that this is a court of law. Why should we use our personal experiences? And as the over-enthusiastic counsel I was at that point of time, I told the judges, sir, if your personal experiences are not to be used in the part of the decision-making process, we may as well ask the governance, the administration to put computers in your place. They would decide the cases. What is the need of the human beings then? And the moment I said those words, notice was issued and the child was ordered to be produced in the court. So, it is my firm belief that howsoever strong artificial intelligence may become, natural intelligence and humanism will always be at the forefront. That is the hallmark of our justice delivery system, and may it remain so. I heartily congratulate Professor Dr. M.K. Bandari Sahab and the entire Galter team for this wonderful conference. I convey my good wishes to the distinguished speakers and the participants who have brought expertise and perspectives to the summit. My congratulations to the winners of the Professor S.R. Bansari Award, Professor C. Rajkumar, who I must appreciate. Your capacity to carry colors with aplomb is remarkable. Really tremendous. And Professor Dr. G.S. Bajpai, Vice Chancellor of the NLU. My hearty congratulations to both of them. I particularly congratulate the young researchers who have submitted their papers and ideas. Your engagement with these questions is precisely what this institution needs and what the moment calls for. I wish ATLEG 2026 every success in its deliberations, and I wish Galter success in its larger mission to build an intellectually serious and ethically grounded law tech ecosystem that produces ideas which are globally relevant, institutionally useful, and morally sound. I am confident that the vibrant discussions in the sessions spread over 3 days will make the conference a huge success. My sincere words of gratitude to Professor Dr. M.K. Bhandari Saab and the entire team of Galter for having given me this opportunity to inaugurate this mega conference, shining with the presence of legal luminaries and brilliant scholars. Thank you. Jai Hind.
Thank you, sir. Much grateful to you for your insightful address, for your inspiring words, and also for your advice for young researchers and academicians. Your guidance and mentorship for young Galterians like us are definitely essential, and we look forward to more of such opportunities to hear from you. Right, sir. And so I also, just a minute, I take pride in saying like you, me, and many others like me in this hall are students of Professor Bhandari. So we are all here because of him. जैसा कि मैंने शुरुआत में कहा था कि मैं अकेला चलता गया और कारवा बनता गया, लोग जुड़ते गए. So I think that's the real story of the day today. With that, we come towards the conclusion of the session today, and to deliver the vote of thanks, I invite Dr. Sindhu Bhaskar. Dr. Sindhu Bhaskar is the chairman and CEO of EST Group, senator at the World Business Angels Investment Forum, and board member of Government Blockchain Association. Dr. Bhaskar has worked his career to global leadership in transforming the financial ecosystem through digital evolution, fintech revolution, and financial inclusion. Dr. Bhaskar, please.
Good afternoon, everyone. Respected Honorable Justice Sandeep Mehta, our Chief Guest, Honorable Justice M.R. Shah, Honorable Justice A.K. Sikri, Honorable Justice Suraj Govind Raj, Honorable Professor Upendra Bakshi, distinguished keynote speaker Mr. Tony Puroni, and my great friend, Professor Dr. M.K. Bhandari, Dr. Shobha Bhandari, esteemed dignitaries on the dais, ladies and gentlemen. It is both an honor and a privilege to propose the vote of thanks at the conclusion of this reinvigorating session, wherein we have been getting all sorts of, I should say, constructive ideas and vigor to fight the artificial intelligence, wherein human intelligence can create its own supremacy. But as we know, there is a virtual inflection point wherein we are fighting artificial intelligence, which is rapidly growing. We are virtually enveloped by swarm of agents, which is agentic AI, which is not only supervising us, but it is guiding us and regenerating. So when we talk of RAG, retrieval, augmentative, and generating, whatever ideas we put it through, it works on it and regenerates and creates a new system for us, a new guideline for us. Now, that is the problem which we are facing, whether human intelligence should prevail over artificial intelligence, or we should have a constant bickering and fight with artificial intelligence. Why did we create it? What is the purpose of it? But it is deeply damning the humanistic attitude of technology, and as the chairman of EST Group, which is basically an impact platform, we try to create AI as the benefactor for humanity. So that is why we talk of decentralized humanism, wherein artificial intelligence can contribute to the social activism, social regeneration, and promotion of humanity, and that will come through ethics. And what is law? Law is our consensus, the consensus mechanism which has found its footing and root, and that is why we use it to give verdict of the day that this rule should prevail upon the, I should say, the antagonism created by different technologies and different misrules. So, of course, we have natural learning models, large learning models, small learning models, so various models, but all models must come together to create the model of humanity, and the guardian has to be the legal centers and our justices who have been talking of how to reconcile all the ends and create a viable humanism. I will not like to take much of your time because we have already passed all the time set for the inauguration. Thank you very much, and thank you, Professor Bhandari, for inviting me, and thank you, Mrs. Shobha Bhandari, because her Saraswati Vandana created a wonder, and I'm one of the few persons who has authored the anthology of poems with her. So thank you very much for honoring me. Thank you very much, everyone.
Thank you, Dr. Bhaskar. And now I would like to invite Professor Bhandari to mention expression of gratitude, to provide an expression of gratitude as Sir desired. So please.
Thank you, Dr. Parajita. Normally, after vote of thanks, the session closes, but at Galtari is known for creating something new. So this is again a new feature. Thank you. Sorry for, I'll not take much of time. It is rightly said that a teacher is reflected in the glory of his student. So, as Honorable Justice Sandeep Mehta ji, when I say him, sir, he says, sir, aap sir mat kahiye. That is the humility he carries. I said, I want to come and just meet you because he was staying as a state guest. He said, no, don't waste your time. कोई ज़रूरत नहीं है, मैं आ रहा हूँ डिनर पे. That is the humility. Otherwise, as a protocol, I should go and invite him. He said, no necessity. आपके साथ कोई formality नहीं है. That is what I wanted to just convey here. Honorable Justice Saha, I met him just 10 days before in our crypto regulation meet. I was one of the advisors. So I said, sir, we are organizing this and can you come? हाँ, जरूर. आप detail भेज दीजिए. मैं आ जाऊँगा. Don't worry about that. I'll manage everything. That is the humility and that is the grace for me. Same with Honorable Justice Suraj ji. Yes, I will come. Don't worry. Tony, my friend, despite all these going on, international disruptions going on, Dr. Joshina, one-day flight cancelled, and for making the visit of Tony and Joshina, I am thankful to dear friend Sri Rajkumar Galtarian for ensuring that yes, she will be our guest at Jindal Global University and we will take care of her travel. Similarly for Tony Rajkumar and for Joshina, Professor Vajpayee, that yes, we will take care of her, don't worry, we know you have a resource constraints, so she will be our visiting faculty. That's what I just wanted to convey. Similarly, Dr. Ashok Jain, he was going USA because he was away from USA for so many days. He is a noted pediatrician. He said, I'll stay here, come, then I'll go to USA. Dr. Sindhu Bhaskar, despite his critical health issues, said, no, it is my event. I am Galtarian, so I'll come from. So he came from Singapore yesterday late night. My friend Georg and Angelica from Germany. So this is what I just wanted to convey and I sought permission. We have many friends. Professor Sancheti, IFS, E.R. Ghanshyam sir, former High Commissioner and Ambassador to several countries. Ruchi Ghanshyam madam was also likely to come, the High Commissioner of India to UK, her better half. She has written a book, A Road to Pakistan, A Lady in the Pakistan, very important book, but because of some health issue she could not come. So I am thankful to each one of you. I may not name a few, please excuse me for that. My elder brother, despite his advanced age, 81, he said, नहीं महेंद्र तुम कर रहे हो तो मैं जरूर आऊँगा. And I am thankful to Professor S.R. Bansali Trust. S.R. Bansali, I don't have words to express. He is my guru. He is my mentor and he is my lifeline. So I don't have words to express for him. And so many friends. I know all my Galter friends, Aparajita, Eklavya, Vipin. Again, naming a few may be discriminatory, so excuse me for that. All have worked hard, day and night, along with me to make this person Naidu. Last minute changes, don't worry, we will do it. Don't worry, we will do it. So I'm thankful to all of you. And as it is said, gratitude is a memory of heart. So I carry these memories for me. Thank you very much.
And sir, we Galtarians are thankful to you. An expression of gratitude from our side also to you for organizing this and making this happen today. Thank you so much.